California Probate Code 850, commonly referred to as a Heggstad Petition, guides the legal process of avoiding lengthy court probate administration procedures by asking a court to order property that should have been but was not titled in the name of the trust to the trust. A powerful, cost-effective tool, Heggstad Petitions can save you time and money. They can also help smoke out any potential trust contests, trust challenges, trustee suspension, trustee removal, or breach of fiduciary duty claims that might be lurking in the wings. What is a Probate Code 850 petition, aka a Heggstad petition? A California Probate Code 850 petition, or Heggstad petition, governs the conveyance of transfer of property claimed to belong to decedent or another person. Generally, an 850 petition is used where a decedent created a trust, but failed to title one or more pieces of property in the name of the trust, the most common properties being real property and bank or investment accounts. The most common scenario, and that which occurred in the Heggstad case, by which the petition is known, arises where the decedent owned a piece of real property, titled the property to the trust, but then removed the property from the trust to refinance it. After refinancing, they then failed to retitle the property back into the name of the trust before they passed. Although clearly intended to be a trust asset, prior to Heggstad, the executor of the decedent's estate had to go through the lengthy court-supervised probate proceeding just to have the asset distributed to the trust, from where then it would ultimately be distributed to the beneficiaries of that trust. A cumbersome, duplicative, time-consuming, and expensive process. Now, with the availability of the 850 or Heggstad petition, a trustee can short-circuit those processes, saving the estate and the beneficiaries significant time and money. How do I file an 850 petition to add properties to a trust? While cursory, an 850 petition is a judicial proceeding that should be undertaken with the assistance of an experienced trust or probate attorney. Why? Well, first, not every situation works. There are specific factual scenarios under which a court will grant an 850 petition. Counsel can help you examine your facts and tell you whether you're likely to succeed or just wasting time and money. Second, because an 850 petition is processed through the probate courts, it's very likely that your petition will produce probate notes. Probate notes will require you to supplement your petition before the court will grant it. Experienced probate counsel can respond to, if not avoid altogether, those probate notes. Third, although seemingly administrative in nature, 850 petitions tend to smoke out unhappy heirs and beneficiaries who may be contemplating trust challenges, seeking suspension or removal of a trustee, or pursuing breach of fiduciary duty claims. A trustee interested in pursuing an 850 petition would be well advised to understand and take into account these considerations when deciding whether to pursue an 850 petition and in drafting that 850 petition to avoid potential future pitfalls. Fourth, some jurisdictions favor Heggstad petitions, while others don't. An experienced trust lawyer can help you analyze whether your local court is likely to grant your Heggstad petition. Litigation involving Probate Code Section 850 petitions. In recent years, litigation involving beneficiaries and heirs claiming that there was a lack of clear intent to add at-issue properties to a trust has become more popular. These contestants see the ability to object to a Heggstad as a possible opportunity to avoid the asset going to the trust and instead pass via intestacy or a will. Although normally the will just distribute the assets back to the trust anyway. In these situations, a trust litigation attorney will be needed to protect the trustee and the trust, as well as the rights of the beneficiaries. When do I need a trust litigation attorney? Contact a trust litigation attorney when you've lost a loved one and don't know what the next steps are. An early call to a trust litigation attorney experienced with the local probate courts can go a long way to ensure a smooth and cost-effective administration. At RMO Lawyers, we're always happy to offer a free consult. Give us a call or shoot us an email. Do I need a trust litigation attorney near me? We recommend finding an experienced trust litigation attorney familiar with the county probate court in the county where the decedent lived. For example, if the decedent lived in Los Angeles, we recommend working with a trust litigation attorney in Los Angeles. That local attorney will generally be more familiar with the local Los Angeles probate court department versus an out-of-state or out-of-area attorney.